Mickey talks the truth.
Okay. I got truth on my mind. Truth on my mind. I got truth on my mind. Truth on my mind. I got truth on my mind. Truth on my mind.
Hey, listen, you are now rocking with Mickey Truth. She live up to her name, not the fame. So make sure y'all subscribe to her channel and stay updated on what's real. Bye.
Good reporting ass Mickey.
We love you, Mickey.
Mickey talks.
Y'all already know all information contained on this live is for entertainment, heavy on a mother effing entertainment, educational purposes only. All information used on this live is per the Fair Use Act, and any conclusion that you draw is on you and your mama, not nobody on this channel, this panel, or in this chat. And another disclaimer for those who have not read the description to my channel, I am not a lawyer. Nothing I say should be used as legal advice because it's not legal advice, okay? If you do need legal advice, however, you can go talk to an actual licensed lawyer or attorney of your choosing, all right? And like the disclaimer says in the video, that you can actually see the consequences of anything that you try to run with from the channel is definitely on you, all right? So with that being said, hey, just sit back, enjoy my opinion based off my free thoughts of what I'm listening to, and y'all let me know what y'all think in the chat. Let's get started.
You can't handle the truth.
Good morning, Truth Team. Good morning. We got Tex in the building. We got Sharice in the building. DJ 804 in the building. We got everybody popping up. Y'all make sure y'all share the live. Y'all give me 1 second. I actually started the live a few minutes earlier by mistake, but it's cool. Y'all know we got to warm it up. For those who have been asking me for an updated video on my surgery update, I just got finished editing and I'm actually about to upload it. That should be out in a few. I'm getting some work done on my car. Yeah, it's a lot going on this morning. This won't be a long. This won't be a long live, but it's gonna be long enough for us to get to the content. Okay. Let's see what I'm doing. Why my camera ain't on? Okay. Good morning. Oh boy, reaction channel. That's what I'm talking about. Shout out to all the creators. All right, y'all, give me a second. And then I'm trying to wait for my mechanic to get here before I actually start, because I don't want to I'm gonna have to walk away. So he should be about to pull up in a minute. And then we're gonna get into it. So in the meantime, between time, y'all know I like to multitask. Let me get this going. But how y'all doing this morning? I didn't even realize it has been a year, y'all. Well, over a year at this point since Julio Foolio was murdered. And to say that we are finally getting a trial, it worked real quick, I'll tell you that much. I will say, for those that keep asking though, the men on this case, okay, won't go to trial until next year, okay? But nevertheless, I'm gonna tell y'all why, to me, this first trial is so important, because although they're going to have other things to add to everybody's trial, we get to see it unfold with the Alicia Andrews trial. Remember, that's the wild card, because a lot of y'all hood nigga bloggers, okay, y'all favorite hood nigga bloggers was saying the girl was telling. But here we are about to watch her trial in the upcoming days. Now, one thing I realized is that the 18th is the first day of trial, but it's jury selection. Normally, especially down there in Florida, they don't stream that. So if we're not live on Monday, it's going to be because, guess what? They're not doing it. Just like with Queso's case, they didn't stream the jury selection, okay? They just started on the trial, the actual opening statements. So if I'm not live Monday, that's the reason. It shouldn't take them too long though. Hold on, y'all. I thought I was gonna be able to multitask. I've been trying to post this for the past couple minutes. Hold on. So last night, I dropped the video saying that Kenny Caps will be testifying, at Alicia Andrews' trial. Boy, they was up in the comments. He snitched. I'm like, bro, we don't even know what he about to say if he says anything. I tell you, it is one thing that never fails. Okay, that never fails. You say somebody get on the stand, the YNs of YouTube gonna say they snitch off bat. Okay, we don't even know what the man gonna say yet. Okay, what's up, Ebony? All right, let me see. Did I share that? What else I wanted to address before we got into the video? And again, y'all, if y'all just coming in, make sure you like, because right now we got more people than we got likes. Y'all hit the like button. Y'all know all I ask y'all to do as far as support of the channel is engage with the content. That means sharing the live, liking the live, and running up the comments. I don't be asking y'all for donations or nothing. I just need y'all to do the free.com for me. So help me out. Salute to everybody that's pulling up. They do love putting that stench jacket on folks without proof. Quickly, Sharice. Okay, quickly. Chelsea, good morning. Good morning. For those that just coming in, I am buying a few minutes. I'm waiting for my mechanic to get here. Okay, so that I can give him my keys so he can get my brakes done. Cause boy, I was out yesterday and the thing was squealing. Okay, and I said, "Ooh, no." So as soon as he gets here, I can go ahead and start. I just don't want to stop it. Once we get started to have to go deal with that. So y'all just bear with me. Like I said, I accidentally pressed go live on this. But hey, y'all know how it go. All right, I got that done. I'll make a thumbnail in a minute. But yeah, so where was I? Oh, let me go ahead and put this disclaimer out here, okay? I know it's a lot going on in the Chicago sector right now. This ain't a Chicago live, okay? We are going to be talking about the Julio Foolio case on this live. Hold on, y'all. Hello. Hey. On live. How many you got today? Oh, okay. Oh, to the actual hospital. Well, yeah, you know the hospital campus. Okay. I'm waiting on B to get her to do my brakes. Cause them things squealing bad. But when I'm only gonna be on live for about an hour or so because the hearing we watch it. For both of them. One. But yeah, when I'm done on live, I'll be on live for about an hour or so. I'll give you a call, but I ain't gonna be on long live today. Alright. Hey, what I was talking about? I forgot. That was my daughter. Alright, let me see how far he is so we can get started. But yeah, so again, just to follow up with the Kenny Caps thing, like he's definitely gonna be there. I mean, he's in prison, not prison, jail. So of course they're gonna bring him. What he's gonna say, I don't know. So you can't really say I had a few even blogs hit me up and I'm like, hey, I can't tell you what he gonna say until it happens. Okay. I don't know. He could get up there and plead the fifth. He could get up there and say nothing. He could get to the courthouse and refuse to testify, which would be dumb though. Like, it's like, don't refuse to testify once you've been served. Like, if anything, just go and plead the fifth. Like, if you refuse, because you just gonna add more. But I guess he said, hey, I'm already facing federal time. But again, this is all assumption because we don't know nothing at this point. Oh, that's what I was supposed to do before she called me. Matter of fact, I might tell him I'm just gonna put my keys outside. Yeah, I'ma put my keys down there in the by the side door because I'm on live. Okay. Well, yeah, that's cool. All right. All right, y'all. Give me 1 second to go put my keys out there. I'll be right back. All right, y'all. All right, y'all. I'm back. Hold on 1 second. 1 second. All right. Boom, 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 boom. Let's get started. All right. So let me pull up. So yesterday, this actually took place yesterday, y'all. Some of y'all, especially that's into this case or into trials, y'all probably already saw it. But shout out to y'all for pulling up to watch it with me. Yesterday, I did not feel well once it actually hit YouTube, so I decided to do it today. And then I got to get back in the habit of actually getting up this early to do stuff, especially to do this trial. So hold on, let me make sure this the right one. Yeah, this the right one. All right. So again, this is a pre-trial conference. Okay. Now, as y'all can see by the title, it says Julio Foolio, alleged killer, can't use domestic violence defense. I know it's been a minute, Truth Team, since we talked about this case, but you remember last year, or was it last? I think the end of last year, beginning of this year, that's when this whole history of domestic violence from her defense start playing out, right? Which a lot of us assume, like, okay, so he forced her to come. What's up, Texas 713? What's up, Rajah? Was Ja? Not sure that's how you pronounce it, but so it's gonna be interesting to see how it plays out. Because if the judge, Nikki, good morning, if the judge has decided that she can't use it, now I wonder what her defense is gonna be. So like I said, this ain't gonna be a long live. I think it's about 42 minutes. All right, so let's just go ahead and get started.
Okay, so we are ready to proceed forward with the pretrial conference. State, are you ready to try this case?
Yes, Your Honor, we are.
Defense, you ready to try the case?
Yes, Judge.
Okay, very good. You can remain seated when you're talking to me. You're fine. All right, so we've got a couple of motions that the state filed. I have not received any from the defense, so we will proceed forward on the motion shortly. I do just want to talk schedule first.
Hold on, pause. Where the lady at? I thought the man left. So did the lady get off the case? I don't know why I thought the man lawyer left. I don't even see the woman. Dang. I was like, where the lady
at? We have 100 jurors for Monday morning, and we will be picking the jury in courtroom 1. Are you, and for the record, Mr. McClimate, I'm familiar with you. If you can tell me your co-counsel again for the record.
Like Malcolm, Your Honor, for the record.
Mr. Malcolm?
Yes, Your Honor.
Okay, thank you so much.
Okay.
And for the state, we have is it Ismer?
Yes, Your Honor.
Harmon and Ms. Doherty. Okay, very good. So Mr. Malcolm and Mr. McClimate, I don't know if you're familiar with courtroom 1. It is over in the civil complex, the George Edgecombe Courthouse on the 6th floor. And when we're done here, if you would like to go over and just take a look at it, I'm sure that would be fine, just so you have an idea. We're gonna pick the jury in that courtroom, but try the case in this courtroom. So we do have a seating chart. Have they been given a copy of the seating chart?
Yes,
Okay.
Yes, Your Honor.
So you can see on the seating chart, it'll be jurors 1 through 100. So you'll be able, when you go into that courtroom, you'll be able to take a look at the seating chart and get a better idea of what, it actually looks like. So this is not a death penalty case, but due to the fact that there may be a number of individuals that know something about this case, I may do a similar process that I would do in a death penalty case, but I just wanted to speak with you all about it. So due to the fact that we'll have 100 juror slips or questionnaires for you all to review, Madam Clerk, what's the earliest do you think we'd be able to get those slips?
What time is it?
Well, I'll have the attorneys be there as soon as you tell me the slips would be available to review.
Probably like 8:45 is maybe the earliest, just because they don't actually start like swearing.
Okay. So I'm gonna ask the attorneys to be at courtroom 1 at 8:30 in the morning. And once the panel of 100 is pulled, the clerk's office does have the ability to send the questionnaires over to the in-court clerk for them to be printed up before we even actually get all 100 people brought over to the courtroom. So what I may do is give you all some initial time to begin reviewing those slips. And then I may do what I would do in a death penalty case, where I do an initial voir dire of the panel with regards to any request for excusal due to scheduling conflicts and also knowledge of the case. And in a death penalty case, I normally do those on an individual basis. So we can see how many individuals we have that raise their hand as far as to one of those 2 questions. And then I can decide how I'm going to do it. But definitely any individuals that have knowledge of the case, that will be done on an individual voir dire basis. And then I'll make a decision with regards to individuals that are claiming hardship once they raise their hand, if I'm going to do that individually or just do it as part of the group. So related to that, I'm going to need a stipulated statement of fact from you all that you've worked on that I can read to the jury. And that way they can at least have enough facts so that way they can hopefully tell us yes or no, I think I know something about this case, or no, I don't. All right. So once I've done the individual voir dire regarding any knowledge of the case, and once I have questioned the jurors about if they've got a hardship request to be excused, then I would begin just my part of the initial voir dire. There's a certain spiel that I do, which takes a little bit of time, not too terribly long. So my point is, I think that will probably take up most of the morning. So whatever juror questionnaires you still need to review, you should be able to have sufficient time over the lunch break to finish your questionnaire review before I turn it over to you all. Just so you know that with regards to the voir dire I will do regarding hardship requests or knowledge of the case, I will do the initial inquiry of the potential juror. And then if you all have follow-up questions, and then I will give each the state and the defense a chance to do follow-up questions of that specific juror, but limited only to that issue, whether it's either knowledge of the case and or a hardship challenge. When we break for lunch, then I will ask you all if you agree to any of those individuals being struck for cause. At that point, if you all agree and I agree, then I will go ahead and dismiss any people that are obviously going to be gone. If either side objects at that point and says, no, I don't agree, it's a cause challenge, I want to try to rehabilitate or I want to question further, then great, they stay on the panel and I don't strike them. I would only strike them if you all agreed and I agreed that it was a cause challenge. Okay?
I don't want to cut you off. There's a co-counsel in the waiting room.
Oh, that's a good question. Yes, thank you.
Thank you.
All right, welcome. Let's see, Ms. White, let me see here. Hello, Ms. White. Good morning. I was just going over kind of the jury selection process, and your co-counsel will be able to relay to you what I said. All right.
No problem.
Okay, thank you. Okay, so any questions just on process for Monday morning?
Nothing from the defense.
Okay, all right, very good. Okay, so I would.
All right. So first and foremost, that's already clear. We're not gonna have. I'm pretty sure they're not gonna stream jury selection and all that. So we probably won't be live on Monday. However, it shouldn't take them that long. It's only 100 possible jurors that they're going through, and I know that may sound like a lot, but it's really not a lot. So probably should only take them a few days to go through that. Picture this and that. What's up? What's up? So that's kind of clear there. So all right, let's continue.
Assume it will take the rest of Monday to pick the jury. Hopefully, we can get it done by close of business Monday. And then we would be, assuming that's the case, we will begin with opening statements on Tuesday and then calling of witnesses. Obviously, if we get bogged down in jury selection and we can't wrap up Monday, then whenever we wrap up Tuesday, you all should be prepared to do opening statements and the state be prepared to call a witness, at least one or two. Just so defense knows, we work 9 to 5, okay? And when I tell you it's a 10-minute break, I mean it's a 10-minute break. And when I tell you it's a lunch hour recess, it's a lunch hour recess. So if a witness is on the stand and it's 5 o'clock and we can finish that witness, then we'll work past 5 o'clock to get the witness done. But I do try and be honest with the jurors about the time commitment. And so it is 9 to 5, but we do move. So I'm not one to linger.
Picture this and that. As soon as I looked up, first thing I saw was you talking about she about to tell at her own trial. Oh my God, y'all fun. I mean, if she like, let me put this is just my opinion. If she was gonna tell, she could have just told without going to trial. Like, why would she go tell at her trial? Like, but hey, maybe y'all. Good morning, humbleness. That was funny. First thing I saw when I looked up.
When it comes to breaks. Anything else, just kind of procedure wise, any other questions you guys have about jury selection trial?
Judge, I know that we are scheduled for 2 weeks and the majority of our witnesses, we have a lot of witnesses that we're making travel arrangements and most of them are available the first week, but there are, I think 2 or 3 that we're planning for the second week. I don't imagine that we will get done early, but I just wanted to make the court aware of that. I know that we were dealing with vacations and there were some other witnesses that are either out of state that are not available until that following.
That's fine, but following week means Monday.
Yes.
Right? Yeah. So if they're not available the first week, that means they must be here and available Monday.
Yes.
Okay?
Thank you, Judge.
Okay?
Your Honor,
Yeah.
is there a time limit on opening statements?
Yeah, there is a time limit on opening statements. You guys each have 1 hour.
Thank you, Your Honor.
Okay?
Your Honor, I have a question as well about
Yes.
scheduling.
Yes.
Do you handle a morning calendar or are you expecting to start
No.
with trial at 9 a.m.?
I just try cases. That's what I do. So there is no morning docket. There'll be nothing interfering. So you don't need to worry about that.
Understood, thank you.
Okay. Okay. Well, if there's no further questions about process, then let's go ahead and turn to the motions.
Judge, we have two limiting motions.
And I did review them and they appear to be kind of fairly standard. So I don't know if there'll be any objection or not, but let's start with the state's motion in limine regarding asking the defendant, counsel for the defendant, to refrain from making any direct or indirect mention whatsoever at trial regarding self-serving hearsay statements of the defendant unless being offered as a confession or admission by a party opponent. Additionally, any self-serving hearsay statements made by the defendant to any other defense witnesses or co-defendant. All right, defendants, any objection to this motion?
No, Judge. I mean, if it's self-serving hearsay under the law, we follow the law.
Okay. And with all of these, I'm going to grant the motion with the understanding that if something changes at trial, and if you all think, the defense thinks that we need to readdress that, you just have to bring it to my attention and let me know before you get into this kind of evidence. All right? So if things change, the door's always open to discuss it.
And just for the record, we're looking at the second motion.
This one is titled State's Motion for Order in Limine, so I think this is probably the first one.
It is.
Oh,
Yes.
like that was filed back in December?
That was filed on the 31st day of July.
Oh, I just have to remember.
All right.
Around right in the middle of the first one.
Yeah, y'all. So all the males on the case is facing a death penalty, and this is not live, y'all. So that's why I'm pausing it. If it was live, y'all know we would just wait to the breaks. But for those who are new over here, but yes, she is facing life because she's still charged with capital murder. She just didn't get the death penalty. So unlike her co-defendants who are being charged with the death penalty, she is not. But y'all know in Florida, capital murder is life. Is no other option. It's either life or death, literally. Okay. Cherie said, I'm very interested in her defense though. Me too. And especially knowing that she can't, basically, because I felt like with the domestic violence, it was trying to say he forced her to go. Because I ain't gonna lie, the first thing I said, for those who was around last summer when we covered this case, I was like, what was the purpose of taking her? You know what I'm saying? I just like, well, she could have stayed home. Like, she brought no substance to going. No matter what she did on the back end, you know what I'm saying? She had no substance to go. So when they started talking about domestic violence, I was like, okay, to say that she was forced, okay, boom, I get it. But now that they can't say that, I don't know what they're going to do.
All right, next up is the state's second motion for order in limine. And this is a number of paragraphs. All of this stuff appears to be fairly standard case law. Is there any objection to paragraphs 1 through 5 of the state's second motion for in limine?
No objection to paragraph 1.
Okay, granted.
No objection to paragraph 2.
Granted.
What in the world?
I mean, no objection to paragraph 4.
Okay, granted.
Okay, well. Judge, can I see the motion you have before you?
Yes.
Because I'm looking at a motion that is, and maybe this was a mix-up on our part. You have one titled second motion
Yes.
for order in limine?
I do.
Okay, all right. All right. You probably have the correct one then. I'm looking at something I think was And I will admit that a lot of this was cutting and pasting from prior motions on other cases.
Sure, here, just take a look at what I'm
Okay.
referring
Thank you,
to.
Your Honor, and I apologize.
And then make sure defense is looking at the same thing.
Okay.
Is he not prepared? I'm gonna be honest. I know it'd be a lot, especially when you're juggling in multiple cases. I understand that. But when you at like getting ready for trial, when I be hearing prosecutors not be prepared or be looking lost or not have, I just be like, what do you be doing? King Newski TV 804, what's up? What's up? Y'all make sure y'all go follow King Newski, okay? He definitely come with all the latest topics that be floating around. But I just like that just be throwing me off. Like, how you not have the right motion? You know what I'm saying? Like, what the world? Oh, boy said she done messed up life wanting to be down. Maybe it's a wake-up call for other young ladies. You would think so. Hopefully her situation will touch at least one. You know, it's gonna always be one behind her, but hopefully it'll touch at least one. Earlier in my comments, somebody mentioned her being pregnant. She was pregnant last year. Like, her due date was February of this year. Now, I can't tell you unless they say it during this hearing. I don't know what the outcome of her pregnancy was. Last night I went looking through old hearing footage. After they gave the due date, they never said nothing else about no baby. So I don't know if she had the baby, like a healthy baby. I don't know none of that. All I know somebody put in my comments she was doing like in a few months. I'm like, bruh, how's she doing a few months and she done been locked up since July of 2024? Like, how long you think you hold a baby? Okay, I'm just saying, like, when do the trial start? Jury selection starts on Monday. Why would you take your chick with you? She played. Yeah, like, that's crazy. Like, she wasn't a shooter, and she wasn't even a getaway driver. Her boyfriend was the driver of the car they was in, allegedly, you know, according to the state's theory. It was like nothing else better. Like, I don't know. That's why I said you could have possibly did the domestic violence, because I don't even know what logical reason it was, but they can't do it. But anyway, let's get back to it.
Yeah, this is right. Yep, that's it. Thank you, Your Honor.
Okay. All right, so far defense stipulated to paragraphs 1, 2, 4, and then are you objecting to?
And 6 was also stipulated to.
Okay, that's granted.
I guess paragraph 5 I don't completely understand, and 3. I guess also I would object to that.
Okay, and Mr. Harmon, in paragraph 3, what is it you're getting at here?
Okay, so in paragraph 3, what we're seeking to prohibit is if a witness has a prior felony conviction or a conviction for a crime involving dishonesty or moral turpitude, such as petty theft or worthless check or something like that, that the defense be prohibited from asking or inquiring about underlying facts of the case or the nature of the charge in that case.
Unless the witness testifies incorrectly.
Yes.
It's crazy he said that, because again, remember, one person that we know for sure that is set to testify is Kenny Capps. Kenny Capps did time as wasn't he a juvenile when he did the yeah, he was a juvenile for the murder of it's been a minute, y'all, since I've been in this sector. What was the that he killed at allegedly. Well, I can't even say allegedly because he pled out to that case. At the football game, what was the boy name that he killed at the football game? But anyway, y'all know Kenny Capps did time for murder. Okay, he literally is in the feds now waiting for drug conspiracy charges and all that. So I'm pretty sure the prosecution don't want the fact that he did time for a killing and all that brought out, because that may taint the jury. Because some of them might be like, oh, you got this murderer up here telling us whatever he's gonna tell us. So I can see why. I mean, it's a good move by the prosecution. You know, that's something we didn't see in Queso's trial because hell, they put all their business out there about past crimes. But this prosecution, like, nah, you can't ask our witness none of that. And it could be because these witnesses are per se not co-defendants. That's just my little unwanted opinion about that, though. But yeah, I can't think of what the boy name was that he killed though. When it comes to me, I know I did a video on it. When it comes to me, I'll let y'all know. I can't remember though.
Okay.
Unless the door's open.
Right.
Somewhere.
So my understanding is that this was number 4. So I'm not sure if 4 and 3 are kind of.
Well, it is basically 4 is just we're seeking to have an understanding as to the appropriate way to.
Spaz, yes, okay. So again, I'm not even gonna say allegedly because he pled out to the murder of Spaz. However, depending on what part of YouTube you be roaming, some of them say it wasn't him, it was somebody else. So again, I don't know about none of that. All I'm gonna tell you that he definitely did time for that case, and didn't too long ago come home. Like, so yeah, that was his name, Spaz. Thank y'all.
Impeach with a prior conviction or crime of dishonesty.
Yeah. So
if 3 is pretty much the same as 4, we have no objection. We don't intend to ask about to impeach witnesses with underlying facts of any criminal cases that they had.
okay. And then the only question I would have on paragraph 3, it does state that concerning the underlying facts and nature of any pending criminal charges.
Right.
So that's a different
it is
analysis than.
So I think in the second sentence of that paragraph, the factual allegations, nature of the charges pending are irrelevant to alleged bias or motive. The state would have no objection to the defense asking about the offense level and the exposure to the witness, the possible sentencing exposure.
And
if it's a first degree felony, then you're looking at 30 years, second degree felony, 15 years. I think the case law that I cited supports the fact they cannot get into the nature of the case and then start trying the case, basically.
And would defense or even state be able to get into the jurisdiction?
I believe so, because it would go to the bias. They would have more possible motive to testify favorably for us if it's here in Hillsborough. So
okay. So, Mr. McClimate, so you all are in agreement that when it comes to the underlying facts of any prior conviction, that's not admissible unless somehow the door's open if the witness doesn't testify accurately. When it comes to pending criminal charges, if any witness has a pending criminal charge, you all would be able to discuss offense level, like what degree felony or misdemeanor, what the maximum penalty exposure would be, and the jurisdiction where those pending charges are.
So yeah, the only objection I would have is that it should be limited to just those 3 things. Right? And I'd imagine, now that it's explained a little bit, that one of the witnesses, Robert Howard, because he does have a pending case in state and federal court, I would imagine that maybe this is to limit any questions as to him. But we did take his deposition, I think 2 days ago. He did testify that he is open for a cooperation agreement, and those questions should be fair game for his credibility.
I agree.
Hold on, pause. I missed that. I don't know if I was dazed out just now. Who they said cooperating? Hold on, I got to go back. Shoot. Did y'all hear who they said? I'm just gonna go back. I must was zoned out just now.
Here in Hillsborough, so.
Okay. So, Mr. McClimate, so you all are in agreement that when it comes to the underlying facts of any prior conviction, that's not admissible unless somehow the door's open if the witness doesn't testify accurately. When it comes to pending criminal charges, if any witness has a pending criminal charge, you all would be able to discuss offense level, like what degree felony or misdemeanor, what the maximum penalty exposure would be, and the jurisdiction where those pending charges are.
So yeah, the only objection I would have is that it should be limited to just those 3 things. Right? And I'd imagine, now that it's explained a little bit, that one of the witnesses, Robert Howard, because he does have a pending case in state and federal court, I would imagine that maybe this is to limit any questions as to him. But we did take his deposition, I think 2 days ago. He did testify that he is open for a cooperation agreement, and those questions should be fair game for his credibility.
I agree.
Okay, that's fine. So,
Well, y'all, for those YNs that was in the comments, it was just verified that Robert Howard, aka Kenny Caps, has mentioned he is down for cooperation agreement. Dang. Like I said, y'all know I was like, hey, we don't know what he gonna say. But cooperation agreement, you don't get a cooperation agreement just to sit there and say you was in a car and you got shot at. You get a cooperation agreement because you about to provide information. Okay. You're about to cooperate is that. So there you have it. Oh, shoot. I'm glad I reminded. I was like, who they talking about? There you have it.
That witness, you can get into the fact that he is specifically stated he's hoping to get some type of cooperation agreement. Okay. And then as a result, I don't know if he's been given one or not, but if he has not been given any type of assurance or agreement, the jury can hear that. Or if he has been given some type of assurance or agreement, the jury can hear that.
Yep.
Okay.
Yes, Your Honor.
All right. So it sounds like after we've discussed it, everyone's in agreement. So that
All right. So let's just clarify. Okay. He want to corroborate, but they haven't said if he got an agreement or not. But just the fact that he wants to cooperate should tell y'all. But hey, that's gonna be interesting. I think that might be the major part of the case as far as content. You know what I'm saying? But yeah. So Robert Howard again is Kenny Caps, Julio Foolio's friend, who was with him the night of his murder. Kenny Caps, the one who went to prison for the murder of Spaz, who is supposed to be the nephew or the cousin of two of the defendants on this case. Y'all got to check out that video. We're going to finish this. If I have time, we'll watch the video where I break all that down, because like I can't really remember. Y'all know I cover a lot of cases, all the details of the situation. But yeah, it's crazy that often that's who is going to corroborate is wild to me.
Paragraph 3 is granted, as we just discussed. Okay, so then 5 is that basically a similar issue?
Well, it's similar in that it would be asking a witness about misconduct or prior bad acts that are not convictions.
Okay. Any objection to that?
Only, obviously, to stay open the door, because they have asked the court to allow them to get into the history of the violence between different gangs and neighborhoods. So to the extent that I'm cross-examining a witness about those things, then I think that is all fair game.
Yeah, I agree.
Yeah,
So
no objection to that, Judge.
It's granted with the understanding that the state has opened the door to a specific bad act or specific act of misconduct, and obviously the defense would be able to question the witness about it. Okay? Okay? All right, and then I think that takes care of that motion, right?
There's a paragraph 6, which I don't believe
They said they agreed to.
They agreed to it. Okay, good enough.
Okay, so, and next up will be state's motion in limine regarding prior incidents of domestic violence between the defendant and Isaiah Chance, and motion to strike defense witnesses Jewel Jordan and is it Jakayla Robinson?
Yes, Your Honor.
Okay. And I have reviewed the motion, so I'm aware of the factual basis. And I guess my first question would be to the defense. Do you oppose this motion?
I do.
Okay, so go ahead, Storty.
Judge, we did take the depositions of both of these witnesses earlier this week, and it became clear that their testimony is solely based on, again, it's self-serving hearsay. They did not themselves witness any sort of domestic violence incidents between the defendant and a co-defendant, Isaiah Chance. All of the information that was the basis of their testimony was relayed to them by the defendant after these alleged incidents took place. There were some visual observations that they made, but Judge, all of this is not only is it with the exception of their observations, is again based on self-serving hearsay, which would be inadmissible, but rather, Judge, this has to go to relevancy. This is a case where the defendant and all of the co-defendants are charged with first-degree premeditated murder and conspiracy to commit first-degree premeditated murder, and any sort of facts or instances having to do with this defendant and the co-defendant regarding domestic violence simply is not relevant in this case. The only possible defense that could possibly go to is duress. And Florida, the law is clear. There is two Florida Supreme Court cases. There are district court cases that are on point that says in a intentional homicide, first degree premeditated murder, we're not talking about felony murder here, duress is not a defense. So why any sort of prior domestic violence instance between this defendant and one of the co-defendants who she was dating at the time would have any bearing to any material fact in this case? It doesn't. So I don't see why they should be able to elicit. That would only serve to confuse the jury. It's highly prejudicial, and it has no bearing to any material fact at issue in this trial, Judge.
Okay, Mr. McLyman.
Judge, so the issue is relevancy, and any, according to the statute 9401, any relevant evidence that tends to be a fact, material fact more or less likely. In this case, the state is obviously charged with first degree premeditated murder. So state of mind is going to be relevant in this case. And state of mind is definitely relevant in first degree murder cases. Case law that I'll cite, Gerganis versus State 451, Southern 2nd, 817 at page 822. It's a Florida Supreme Court case from 1984, which states that to convict an individual of premeditated murder, the state must prove, among other things, a fully formed conscious purpose to kill, which exists in the mind of the perpetrator for a sufficient length of time to permit reflection, and in pursuance of which an act of killing ensues. Obviously, this element includes the requirement that the accused have specific intent to kill at the time of the offense. So when specific intent is used or is an element of the crime charge, the case goes on to say that evidence, and it says evidence of voluntary intoxication because this case is about voluntary intoxication, but then it says, or for that matter, evidence of any condition relating to an accused's ability to form a specific intent is relevant. And so we're arguing here that the state of mind comes in when the state argues that Alicia Andrews' motive and intent to kill was based off of this gang beef back and forth, and also when the state argues that there are actions that Alicia Andrews took that represent or can be interpreted as actions to prove intent or motive to conspire with her co-defendants or to kill Charles Jones. So to rebut that argument and that evidence, we should be allowed to put forth evidence of what Alicia's true motives and intent were. That's her state of mind again. That's why it's relevant. And also there's other case law, Roundtree versus State 113. This is a Supreme Court of Florida case. So the citation is different because it's from 1934 of the state. 113, Florida 443 at page 447, and it's 152 Southern 20,21. That case says it has never been held that the defendant's privilege of becoming a sworn witness in his own behalf, in this case in her own behalf, has deprived, although subject to cross-examination on his testimony, has deprived the defendant of his right to detail facts which tend to throw light on his own motives and individual intent in being found in a particular situation or in doing a particular act when such motive or intent has been put first, put in issue by the prosecution. All right, so it's clearly relevant. It's long-standing case law that state of mind is relevant in a first-degree murder case, and in this case where we have evidence that would show the jurors what Alicia Andrews' state of mind was when these actions were occurring, is clearly relevant and admissible.
Well, wouldn't her state of mind as being a victim of domestic violence, particularly a victim of domestic violence by Mr. Chance, co-defendant, Wouldn't that only be relevant to a duress defense?
No, I mean, it could also be relevant to a duress defense, but it's relevant in this case to the intent element of the charge. It could also, I mean, if duress was a legitimate defense, if we could get a jury instructions to duress on this case, then yes, it would be relevant to duress and to intent. But it doesn't solely go to duress.
Okay. Okay, any rebuttal, Mr. Ording?
Judge, obviously we have to prove state of mind. That is relevant. But when we're talking about, this is not a self-defense case where she has killed her attacker. In that case, you clearly would be able to explore that. It would go to a potential defense. This is not a self-defense case. And so the only other fact that would, or defense that would go to would be duress. And they're not entitled to a duress defense. And so we're very concerned with any sort of confusing the jury and them being able to explore or elicit any sort of facts or statements about any concern that she may have for a co-defendant. And that's what that case law, that Florida State Supreme Court case law cites to you. It doesn't matter how afraid or scared you may be of one of your co-defendants. In fact, that Cole case is a woman who was charged along with a male co-defendant of first-degree murder and conspiracy to commit first-degree murder. Duress is never going to be an excuse if you're fearful of your own life to take another's life. And so that is the point. The jury shouldn't be able to hear any sort of issues that she does have with a co-defendant, because that defense is not available to her for first-degree premeditated murder and conspiracy to commit first-degree premeditated murder.
And I agree with what the state is saying as it relates to a duress defense and a duress instruction. We're not asking for a duress instruction, and we're not putting this in for the purpose of proving a duress defense.
Well, then what in the world would it be relevant to? That's the thing I'm trying, I don't understand the relevancy then. Because if you're not arguing defense, what does it matter if her co-defendant committed domestic violence against her? So why is that relevant?
I'll proffer at least one fact in this case. So in this case, the state will put on evidence that Alicia Andrews gave Isaiah Chance, her cell phone, so that either he could conceal his identity or that she could help him commit the crime in this case. And the past incidents of domestic violence, I'll proffer to the court, is that situations where Alicia Andrews was forced to give her phone over to Isaiah Chance, was beat, was dragged, sometimes even sort of like kidnapped in his home for not giving up her phone and for texting other individuals on her phone, right? And so in this case, where the state is saying, hey, she gave up her phone willingly, she gave up her phone for the purpose of planning this, or helping to plan this murder, it's not the case. Her intent for doing that, her motive for doing that is completely different, right? And it's the past, the domestic violence and the past facts that I just brought to the court that would shed light on why she's in a position where she feels that she has to give up her phone or can't leave and turn around and go another way because she's been abused by this individual in the past. And likely, if she doesn't comply with what he's saying, the same thing could happen to her in this situation. So
wouldn't she have to testify for any of that to come in?
She would.
Okay, so here's what I'm gonna do. At this point, I'm gonna grant the motion without prejudice, okay? So, regards to the motion for order in limine, you all are not to get into any prior incidents of domestic violence between the defendant and as Isaiah Chance, her co-defendant. However, if it appears to you that you think it's now relevant, we just need to talk about it before you get into it. Okay, so I'm granting the motion without prejudice to review it. With regards to the motion to strike the defense witnesses, I'm going to reserve ruling on that. I'm not just going to strike them at this point, but again, before you were to call them as witnesses or even discuss what their testimony might be in front of the jury, you can't do that until you've gotten permission from me. However, I do think, do you have a defense witness list other than just these two witnesses?
We have a cell phone expert
Okay,
that we listed, and that's it.
that's fine. Because when we're doing jury selection, I'm going to ask you to identify any.
All right, Paul, that was a lot going on. My bad. I was over here trying to do multiple things, but I don't, like I said from the beginning, right? I couldn't help. Good morning, Brittany. Good morning, everybody. Mr. Wall. Let me tell you, I still don't understand why she went or why she had to go. Like, she was like, to me, and I said this since July when we first found out she was involved, she served no purpose to being a part of the plan. Like they said, I already said she doesn't have actual gang ties. She, she didn't get out the car to be one of the actual shooters, nor her boyfriend, right? So her only link to it was that her boyfriend was there. You know what I'm saying? So by taking out the domestic violence, I'm really interested to see how the defense will play their case for that. But I do like this judge so far. Okay. Like, I don't know what Broward County be having going on, but the judges in other parts of Florida, they be together. Hey, listen. So, look, this one mix, I bet she wish she wasn't a part of, okay? But let's finish. I think we got like 12 more minutes left.
Potential witnesses. So go ahead and include the names of these two witnesses on your list, just to make sure that none of the jurors know any of your defense witnesses. But again, we're doing this with the understanding that they're not going to testify, and you're not going to discuss what their testimony would be unless you've asked me to revisit this and I have told you, yes, this is now admissible.
And I also want to add to my argument.
Hold on, you said, wait, so defendant, co-defendant, why are they saying that? Because only one person going into trial. Is what, 5 people on this case? And only one is going to trial. The only female is going to trial right now. The other 4, according to Hillsborough court records, they don't go to trial till April of next year. So when you hear co-defendants, they're referring to the men on this case. She's the only one that's standing trial right now. Also, dang, was something else I was about to say. Yes, her phone is key evidence, because in the documents, in the probable cause warrant, they said that she reached out to people to try to get them to put the Airbnb in their names. Like, they have a lot of, she was the secretary, okay, to like pop everything off. That's why I said she could have secretary from home. You know what I'm saying? Instead of going actually down to Tampa. But yeah, so far, just to clear it up again, it has been no mention that Alicia Andrews is cooperating in no way. We have heard that Kenny Capps is cooperating. We have heard that people that Alicia Andrews have reached out to will be testifying against her. So again, at this point, we have not heard anything about her doing anything. Now, mind you, the whole rumor about her cooperating was when she first got arrested. She admitted that her and Isaiah was in Tampa, and that everybody just ran with that she was going to be telling. But so far, I mean, you turn out 18 years. I mean, you get what I'm saying? So obviously, she probably could have had the chance to cooperate, but she hasn't. So let's keep going.
The state, back in December, they filed a motion in limine to get into a bunch of evidence about different gang wars and beefs in Jacksonville. And they said that was relevant to prove motive and intent as to Alicia Andrews, who's not in a gang. He's not even affiliated with a gang, according to their own witnesses and their own detectives. And that was somehow relevant to Alicia's state of mind. Something that has nothing to do with her, really has something to do with her co-defendants, and somehow that is relevant to her state of mind. But here, the state is arguing that things that have actually happened to her and reasons as to why she may have been in the position that she was in are not relevant to her state of mind, but yet something that happened years prior, something that has nothing to do with her, is relevant. So, I mean, it seems unbalanced. If we're going to have a trial and there's going to be evidence put forth about all this stuff, and Alicia Andrews can't talk about why it is that she was in a position, she was in a car with an individual, why she was giving up her phone, why she may have been outside of a club with an individual, why she didn't call the police and all these different things. If she can't talk about that, it just seems to me as to be unfair.
Well, and again, that's why I asked you about the only way this comes in is if she testifies. Now, if she decides to testify, then we will have another discussion about this. And by then I will have heard all of the state's evidence, and then I'll be able to, again, consider whether or not any of this testimony would now be relevant. Okay. So
I guess in jury selection, I don't want to step on any toes or do anything, incorrect in jury selection. So if I'm asking questions about any sort of domestic violence, I wouldn't want to draw an objection and maybe shut.
I ain't gonna lie. She looked stressed out. Let me move that. She looked stressed out. Like she looked like life is lifing. For sure. Okay. Life is lifing. Is it true that she rented the Airbnb? Well, the actual Airbnb was in the name of one of the co-defendants, but she was the ringleader to set it up though. But yeah, she definitely looked stressed. Her hair be nice though, for sure. The hair be nice, but yeah, she looked stressed.
Down if it ultimately comes in.
well, I don't, Steve, would you object if the defense just generally talks about or asks the potential jurors, have you ever been a victim of domestic violence? Have you ever been accused of domestic violence?
Judge, I would be just for this very fact. We don't know if she's going to testify. And again, even if she should testify, it is not relevant. It doesn't, we would be arguing again and objecting to any questions posed to her regarding any instances regarding Isaiah Chance. I think the law is very clear.
I understand.
So hold on. I guess she's like, hey, so the state is like, at this point, ain't no need to bring in domestic violence the whole trial. And we don't even know, because again, they don't ask the defendant if they're going to testify to the end. So they're like, hey, y'all be done tainted our case, and then she choose not to testify, then what? You know what I'm saying? So I get what they saying with that though, for sure.
Dan, I know you may disagree with me. I'm just saying, if, and there's a lot of ifs built in here, but you guys only get one chance to talk to this jury. So I'm kind of layering one scenario on top of another. So I just want to make sure that both sides have the ability to be very thorough with any potential jury panel members. And I don't really see the prejudice to the state if just generally speaking, because you're going to be talking to these jurors about if they ever been a victim of a crime, have you ever been accused of a crime? And I don't think there's any prejudice to the state if you're allowed to more specifically get into, and just while we're discussing it, because this is a murder charge, it's a crime of violence. Have any of you ever been accused of or been a victim of domestic violence? I really don't see the prejudice to the state during jury selection.
Your Honor, if I could suggest if that inquiry is allowed, and I understand the court's ruling, that it not be stated to the jury that an issue in the case.
Correct. So
I agree with that.
Okay, that's fine.
Your Honor, your ruling concerning us, either party getting into that issue that has been addressed in this motion, that obviously applies to opening statements.
That's what
I just want to make sure we're all.
Yes, there's everything so far. If I've granted the motion in limine, it's not coming in at all, not in opening statements, not in any question of a witness, not jury selection other than what we've discussed here, the exceptions, unless you, outside of the presence of the jury, the defense has come and said, listen, we now think this is why it's relevant and we want to revisit it. Okay?
I mean, we would like to get into it also in our opening statement. I don't know if we.
I know you would like to. I would like to be, 20 pounds lighter. However, that's not going to happen anytime soon. So I understand this is what you would like to do, but listen, if at some point this evidence becomes relevant, in your opinion, you can renew your motion and we'll discuss it. And then at the appropriate time, it would become, if I think it was admissible, and come in, but not at the beginning. Okay? All right.
And Judge, as far as the defendant's testimony and this issue, that would obviously be something that would be addressed in a proffer outside the presence of the jury if the defense believes it's relevant, that they would present that to you outside the presence of the jury.
Yeah,
initially.
Once the state's rested and the defendant is making a decision whether or not to testify, we will have this discussion again, okay? Because then, like I said, I will have heard all the evidence, and I'll be in a better position to know what I think might be relevant or not. All right?
Just, I guess if there's any record that needs to be made, we object to the.
My bad, I started typing and I messed up the video. Hold on, it's almost done though. Kiki, I'll answer that in a minute. Let me finish this out. Dang it, I got the pressing too many doggone buttons on my computer. All right, let me see how much we got. Shoot. All right, hold on, y'all. My bad. I got to doing too much. I was over here doing homework, all types of stuff just now. And it started all the way over. Hold on. Refresh. I think we was at like the 38. I'm going to start back at like 38.
On the night of and the night prior to the shooting. So anything that he testifies to will be information that they've had longer than we have.
Okay. But I mean, did he give you his opinions, or was it just I'm working on this? And
he did not give me opinions, Your Honor, other than he did not find any errors in the extraction of cell phones, but the extracted information from the different handsets and cell phones is not part of his mapping. So that was really the only opinion he gave me on something that apparently is not going to be presented by the defense. So it's the maps that we're concerned about. At this point, having not even seen them, I can't really.
Okay, so I tell you what, I know you guys are going to be busy, but you'll get the maps no later than noon tomorrow. If you get them by 5 today, obviously send them as soon as you get them, okay? If there's an issue, I would ask that you make your expert available Friday for an informal discussion, all right, Mr. Harmon? And if you think there's a need to redepose him or depose him, we can break early Friday and we can leave Friday afternoon open, okay?
Okay.
If need be. So just let me know by Monday if you think you need to depose him. Okay?
Let you know by Monday?
Yeah.
Okay. Will do.
Yeah, just so I know for scheduling purposes.
Oh, next week, Friday. Okay. I misunderstood. Okay.
No, this Friday, I want you to have an informal discussion with him.
That prosecutor be confused a lot, okay? I'll answer y'all questions just 1 minute. Let's finish out these last couple seconds.
You get the maps.
Yes, Your Honor.
And then if you think it's going to be necessary to do more formal discovery, i.e. taking his deposition, then that can happen next Friday afternoon. Because I don't think you all will have rested. From what I'm hearing, all of your witnesses are not even available till the following week. So next Friday afternoon, if there needs to be catch up on any discovery, that's when we could do it. I just need to know before we begin selecting the jury so I can let the jury know what the schedule is, so that way they can manage their lives. Yes. And I may break a little early on Friday just because. We'll see.
All right.
Okay. Anything further?
Judge, the only thing else in the state is all offers of proffering the defendant are revoked. We don't anticipate engaging in any kind of plea negotiations from this point going forward.
Okay. Ms. Andrews, you understand the state is revoking any plea offers to you. Do you understand that?
Yes, ma'am.
Okay.
The only other thing I have is that.
All right. No plea offers on the table anymore. No plea offers on the table anymore, which makes sense. I mean, you're on the eve of trial.
State witness Robert Howard is in custody, and I'm not sure if the state has already had the transporter signed back brought here.
I think, let me look. There was a writ someone signed.
Yes, Judge.
Sounds like Robert Howard is the key witness here. All right. So jury selection starts Monday the 18th. Okay. Jury selection starts Monday the 18th. They're expecting to start actual trial with opening statements the afternoon of Tuesday afternoon, according to how the judge sees it. Okay. So again, what have we learned from this? We have learned that any plea offers, plea deals that was offered to Alicia Andrews have been pulled from the state. I mean, because she's about to go to trial. We have not heard anything about her cooperating in any way. However, we have heard in this hearing that Kenny Capps, aka Robert Howard, is okay. We also have heard that other people that she was in communication with, as far as setting up the Airbnb and all that, is set to testify against her. Okay, so this is going to be an interesting case. Interesting case. Okay. So the state making her go to trial. It's not for the state. The state can't make nobody go to trial. That's a defense situation. Because she could have played out. It was pleas on it. She could have played out. Obviously, the pleas wasn't what she wanted. You know, at the end of the day, 18 years may seem like not that much when you compare it to life. Good morning, Blue Skies. However, 18 years flat out when you could beat the case, and that's why she's going to trial. Because in her mind, she feel like she has a better chance to possibly get, you know, empathy from the jury and go home. I mean, you know, I know me personally, 18 years is life to me. Like, I don't care how, I know it's not life, but it's life, okay? To me, okay? So I'll take my chances at trial. I don't care what the probability is, it's a chance I might beat the case. I'm gonna go to trial because 18 years is life to me. That's like, if all my only options is 18 is life, and life is both the same in my eyes. You know what I'm saying? So that's just how I'm feeling. They're not offering no plea. All pleas that was offered are now off the table. So they offered, she didn't take it. That's that. We're going to trial. Shout out to old boy for the membership. I appreciate it. Shout out to all my members. So that's where we are with that. Okay. So again, she's not cooperating. She's not telling on nobody. We don't even know if she's going to testify in her own defense at this point. Humbleness said, I'll take the 18. Hey, you're a stronger person than me. Like I said, it's the same. Hell, you can send me to a year, and that's going to be life for me. I'm not fooling with it, okay? I'm going to trial. Especially, and this is the thing, especially, you know what I'm saying? Especially if, I'm taking my chances at trial. Mickey, she in the video at the party, she don't have a chance. She wasn't at the party. That I got a whole Julio Foolio playlist on my channel because, boy, it was a lot going on last summer with all the allegations and stuff. Make sure you check that out. But no, Alicia Andrews was not at Julio Foolio's party because at the same time that the girl who looked like her was there, guess what? They had Alicia Andrews in a car riding around with her boyfriend in Tampa. So it wasn't Alicia Andrews at the party. It's not be offered now, guys. It was on the table. Right. Exactly. What was the original plea? I don't know. I'm hearing people say, 18 years. I don't know. Like, to be honest, I don't too much really get into the pleas unless they take them. But I'm hearing online, and y'all was in the comments earlier saying it was 18 years. So I guess 18 years. We heard that Scotty got offered 15 years. But listen, anytime, especially when it's multiple defendants, anytime you take a plea, you gotta be careful what you pleading out to because they may want you to cooperate, and I'm pretty sure they probably wanted her to cooperate. Not saying that that's the only plea they could have offered, but I'm just saying in this situation, because she was actually there, she could have been the butter in this case. But for those that's more into like the whole street shit, y'all might be like, oh, she's staying solid. It is what it is. How many charges she got? Why? Hold on. Let me pull it. How do I say, why does that matter? I know for sure she got 2, but hold on. Give me a second. Give me a second. I ain't looked at this in a minute, so hold on. I think it's like 2 or 3. If I'm not mistaken, I think it's like 2 or 3 charges. I done did my whole life, and my mechanic ain't even got here yet. The fuck he got going on? I done sent him my money for my parts too. I hate to have to pull up, cause I don't know what he got going on. My bad, y'all. Cause I'm like, he was supposed to be in here over an hour ago. I done did my whole life. Hold on, it's loading, y'all. Give me a second. It's loading. It's loading. Stop sharing that. Why is it taking so long? I might need to restart my computer. Charges. It matters whether I take the 18. I don't care how many charges. 18 is 18. Whether it's 18 years for one charge or 18 years for 10 charges, I'm going to trial, okay? Because you got to, a jury got to tell me I'm about to do time. Like, I'm just saying. Now, again, oh, she actually only got 2. Let me show y'all. Yeah, she only got 2. She got murder in the first degree premeditated and murder in the first degree. Damn, it's basically the same charge, but yeah, she only got 2. Yeah, okay, listen. I'm going to trial. Like, I am going to trial. That's it. No, she's 21. I know a lot of people like, well, and you know, cause again, 18 years. Hell, I done raised a child. So, I mean, you think it does go fast to a certain degree, but in prison, listen, you don't know if you can even make it in jail or prison for 18 years. Like, we don't even know we're going to make it through life, okay? Emmanuel said, didn't they say they will they will not give her a plea? They said they're taking the plea offers off the table. So, let me re-say it. So they offered a plea, she didn't take it. Now they're saying, well, it's off the table. So even if she changed her mind tonight, she can't. It's no plea to take no more. Her time to accept the plea is out, and that's normally how it goes. They give you XYZ amount of time to take the offer. If you don't take the offer or whatever, but you know who is taking the offer possibly? Kenny Caps for sure. All right, y'all. I got to get up off of here because I got to go figure out why the hell this dude ain't got here to do my car after I done sent him $100. And I hate to have to pull up. Okay, so I'm going to go take care of that. Y'all already know more content on the way. Humbleness said, I'm taking 18 because that light hip different. You doing 15 off 18. Fuck that. Look, shout out to Humbleness. I'm going to trial. Okay. I am going to trial, especially, and then my thing, especially if you like, if you really in it anyway, I'm going to trial. I'm not taking no chances with it. That premeditating gonna hurt. Wonder what the evidence they have to support premeditating. Well, the fact that she pre-planned the Airbnb, you gotta remember, and those who wasn't around for the Queso trial, just keep this in mind as we go into this trial. It's all about the storyline. Okay, the storyline, according to the state, and I don't even know what their storyline gonna be for trial, but according to their probable cause, the storyline is the girl was the one to set the arrangements for everybody to go down to Tampa to ultimately unalive Julio Foolio. So premeditation is that they came from Jacksonville to Tampa to do this murder. They stopped him, all that. So that's the premeditation. It wasn't like, now if it was in Jacksonville, maybe they could have like argued it wasn't premeditated because they're in the same place, but they had to travel. It's like 3-4 hours from Jacksonville to Tampa, something like that. But yeah, I got to get off here because I'm really, my nerves getting bad while this man ain't showed up and I'll pay him $100. So I will see y'all again on the videos between now and next week on live. If which I doubt, but if they stream jury selection, we in here on Monday. If not, we are in here Tuesday afternoon, as long as they stream it. And okay. So with that being said, y'all make sure y'all like, comment, share, subscribe. Tell a friend to pull up on your girl, Mickey Truth. Y'all know everything I said in this video is definitely my opinion. And y'all know how I feel about my opinion. And like I said throughout the video, that's my opinion. And if you don't like it, guess what?
I'm like, fuck, yeah. Mickey talks the truth.
I got truth on my mind. Truth on my mind. I got truth on my mind. Truth on my mind. I got truth on my mind. Truth on my mind.
Hey, listen, you are now rocking with Mickey Truth. She live up to her name, not the fame. So make sure y'all subscribe to her channel and stay updated on what's real. Bye.
Good reporting ass Mickey.
We love you, Mickey.
Hold on, wait, before I go, y'all make sure y'all tap in with me to book your slot. A lot of y'all be hitting me up on Instagram and the email wanting to just talk about content, whether you're an up-and-coming content creator or somebody just got questions about cases or whatever. Book your consultation with me now. The information is on the screen. Hey, make sure you get your slot.